Welcome back, America. I'm Hugh Hewitt, live in Studio North today. David Rivkin is with the law firm of Baker and Hostetler and one of the country's most esteemed appellate litigators. Two things I wanted to talk to him about. A letter he sent on July 25th to Dick Durbin and Sheldon Whitehouse of the Senate Judiciary Committee, and an op-ed he co-authored this month with Lee Casey in the Wall Street Journal. Good morning, Mr. Rivkin. Welcome to the Hugh Hewitt Show.
Good to be with you.
Well, let's begin with the op-ed in the Wall Street Journal. I just discussed this with Chris Christie and with Tom Cotton. They agree with me and with you that the attempt to regulate the conduct of Supreme Court justices is unconstitutional. Has anyone of any serious credentials stepped up and said otherwise?
Well, depends on your definition of serious credentials. It's clear that the Senate Democrats are driving for a much more prescriptive and prescriptive regulation of the Supreme Court. And what they particularly have in mind is the standards of recusal, which are now quite broad and consistent of common law. Financial interests, an advocate who's a member of the justice's family, to a situation where it would be easy to recuse Supreme Court justices, and the recusal decision, instead of being self-enforced by the justices, would be done by somebody else. A suggestion in the bill that the Senate Democrats put forward is to have 5 circuit court chief judges. And that's unconstitutional in a variety of ways. But what they're really trying to do is to impair the ability of Supreme Court to function.
Well, as Senator Cotton just pointed out, the Supreme Court is a constitutionally established court. The lower courts are not. And Chief Justice Roberts is the Chief Justice of the United States, not of the Supreme Court. It's simply textually without precedent. Justice Alito said so to the Wall Street Journal. He was criticized for that, but ought he to remain silent when people are slurring him every day?
Of course not, especially since the organized bar that in different times would have come to the court's defense is not doing it. Look, it's intensely ideological. I mean, the Democrats are talking, they're clearly not happy with the court's jurisprudence. It has nothing to do with ethics. It has everything to do with trying.
I think we froze there a little bit, David Rivkin, so I'm going to try and reconnect there. Bandwidth is always an issue, even when you're dealing with Beltway folks. Folks, can we reconnect with Mr. Rivkin? Because the July 25th letter is where we're going to go next. And the July 25th letter begins, "We write on behalf of Leonard Leo in response to your letter of July 11th. This is to Sheldon Whitehouse and Dick Durbin, which requested information concerning Mr. Leo's interaction with Supreme Court justices. We understand this inquiry is part of an investigation of certain members of the Senate Judiciary Committee have undertaken regarding ethics standards in the Supreme Court. It makes the following charges. Your investigation of Mr. Leo infringes on 2 provisions of the Bill of Rights. First of all, it appears to be retaliation for the exercise of First Amendment rights. And secondly, it cannot be reconciled with the Equal Protection Clause of the Due Process." Mr. Rivkin, good to have you back. I was just reading your letter. What is the reaction from the letter that you sent on July 25th? Has either Chairman Durbin or Senator Whitehouse responded?
They have not responded. They have, however, sent a letter to the Chief Justice, in essence, doubling down on their views of when a recusal is appropriate. I have to say it is stunning. The Supreme Court, by the way, Hugh, has addressed this issue in the past. There's an excellent opinion by the Chief Justice Rehnquist in a case called Led versus Tatum, where his recusal was sought because of his prior job at the Justice Department. He was the Assistant Attorney General at the Department of Justice. And it's a very robust discussion of the standard for recusal, looking at all the other instances where that has been done. I mean, one point to underscore for your listeners, we're really talking about the political interference with judging. The recusal decisions in each case are part of judging, because that's something you do in the front end in the context of a particular case in controversy. And it's not often that opinions are written, but you have a couple of opinions written by the late Justice, by both Chief Justice Rehnquist and it's absolutely clear that their position is not consistent with historical practice in this area. And there are two opinions by late Justice Scalia. You may remember the famous case that involved the Vice President Cheney, and the whole hunting accident. So there's what I would say a magisterial write-up by late Justice Scalia.
A cheeky opinion. Stand by, Mr. Rivkin. I'm coming right back because I believe the attack on Leonard Leo ought to chill everyone who lives in the public space and advocates for anything that a majority in either house of the Congress does not like. We're going to come back and talk with Mr. Rivkin, play it tomorrow morning, on what he is alleging in this letter and whether or not there is behind that the threat of a lawsuit down the road. I don't know that they can be sued for what they say about Leonard Leo in the Senate itself, but what they say outside of the Senate, they're getting awfully close to slander. David Rivkin, lawyer with Baker and Hostetler, who represents Mr. Leonard Leo, famous for the Federalist Society, of course, and also for being a brilliant advocate for center-right positions and originalism in the United States. He built the Federalist Society. He's been instrumental in all of its growth and the fact that we need a second option for law students on every campus because most of the illegal academies gone far left. I thank Leonard for that. But I've only met him once. I actually don't know Leonard very well. I've never met Mr. Rivkin that I can recall. But I want to talk to you about three things. The two constitutional arguments you lined up on behalf of Mr. Leo and the fact we've got a double standard on ethical conduct by the Supreme Court. Let's start with the last one. I do not believe that Justice Breyer has been a guest on this program, or Justice Ginsburg, the late Justice Ginsburg, or Sonia Sotomayor, or any of them have violated any rule of ethics. I want to make sure everyone understands that. Do you agree with me?
I do.
So,
I do.
But there is a double standard. Can you explain what that double standard is? They're going after Justice Alito on a fishing trip 15 years ago, and they're looking past the Sotomayor book deals.
Yes, as you put it, the kind of contacts that they claim are disabling for conservative justices are similar to travel. I mean, look, justices are human beings. During the time the court is out of session, it's not unusual for them to be invited to conferences to speak about the law. It's not unusual for them to have friends. It's not unusual for them to go on a fishing trip. It's not something that should be singled out as a particularly unusual exercise. And it is intensely focused on both Justices Thomas and Justice Alito. None of the liberal justices, in my opinion, have done anything wrong. Justice Breyer, for example, has had hundreds of overseas trips where he traveled very well. The trips being paid by the people who invited him to speak.
I can also speak specifically to Justice Breyer, who was a guest on this program for 2 hours when he was selling his book on the Supreme Court. And I was glad to have him. It was a great interview, and it made a lot of sense. He then went to the Nixon Library, on which board member I am. We always guarantee we will buy 500 to 600 books, and we will sell those books at a premium. They sell tickets. And the justices come, like Justice Gorsuch and Justice Breyer, to the Nixon Library because it's a New York Times accredited bookstore. They want to be on the list because that sells more books. It's completely ethical. There's nothing ever been raised about it. Does anyone respond to that? And do you see that being covered anywhere in the media that's all over Justice Alito for a decade and a half ago fishing trip?
Unfortunately not. And one other thing I wanted to emphasize for your viewers, as far as disclosure is concerned, which is what did he have to put in his financial disclosure form, the standards that existed at the time, they were changed by the Judicial Conference of the United States. And by the way, the Supreme Court does not have to follow this regulations promulgated by Judicial Conference, but as a matter of comedy, they do. Several months ago, in March, if I'm not mistaken, both standards got changed. So both disclosures by Justice Thomas and Justice Alito back with respect to the fishing trip and various things regarding Mr. Crow, who is a friend of Justice Thomas, were entirely consistent with the standards that existed at the time. I have not seen any newspaper, mainstream newspaper, make this point. In fact, they're all pushing the same line as ProPublica, but this is somehow was a violation as far as non-disclosure is concerned.
Now, I want to switch to Leonard Leo because I think this has a tinge of Army McCarthy hearings to it. And I think if Leonard gets up there because of a subpoena, he will take them apart, shoulder and muscle. But I don't want it to happen because it chills speech. Would you explain the two constitutional provisions you believe their request or their demand of Leonard Leo to appear before the Judiciary Committee violate?
Of course, it first of all singles him out for his speech. So it violates his First Amendment, both expressive and associational components thereof. And the fact that they're focusing on him and not focusing on other people have relationships, professional friendships with the justices is a classical First Amendment problem where he's being pursued for the content of his speech. It's also an problem of an equal protection component of a due process clause of the Fifth Amendment. And very importantly, it's lacking valid legislative purpose because remember, Congress's investigative power only exists because of its legislative power. Our view is that you cannot promulgate constitutionally, and we talked about it a few minutes ago, the kind of ethics code for the Supreme Court without impairing its independence, which is absolutely essential to our constitutional architecture. And that lack of legislative purpose renders the investigatory effort entirely illegitimate. So they're really three constitutional issues: First Amendment, Equal Protection Clause, and lack of valid, and let's call it structural separation of powers.
Now, it's an 8-page letter, and I would encourage everyone to put it into their case books and to teach it in their con law classes. I will, because it does explore very fundamental issues. But I want to focus on chilling people's speech. If they can do this to Leonard Leo, they can do it to any reporter, to any public person, to any private citizen. Drag them up there, make them incur the cost of having a representative like you advise them. And basically, it's a threat to conservatives to shut up and stay quiet. Is it a prelude to bringing an injunction against a subpoena of Mr. Leo, should one issue?
Well, let me say two things. It is not a subpoena right now. It is a request. They can convert it into a subpoena. And if they do that, obviously it would help. You're right. It has a chilling impact. Watching it being done to Leonard chills not only his particular speech, but chills the speech of other people. My hope is that they would stop. They would not proceed with that. But right now we have nothing to try to suppress. But they can convert it into a committee subpoena, in which case we would fight.
By that I mean you would file an attempt to enjoin it.
That is correct. Well, quash would be the
quash is the technical term. I am curious about what you think the odds are in the District of Columbia. Is that where you would bring it, by the way, or wherever Leonard Leo is living?
Well, I don't want to talk about venue. It's a little premature. But look, I don't agree that, and this is not something for the jury, it's pure question of law. It's possible, not easy, but it's possible to draw a good judge on the district court bench. It's possible to draw a good panel in the D.C. Circuit. But ultimately, that would go to the Supreme Court. You know, it's interesting. If we're litigating not just the First Amendment, if we end up litigating, which I hope we would not, the lack of legislative purpose, that actually is the best way of dramatizing why what Senate Democrats want is unconstitutional. And I'm sure that Senator Whitehouse and Senator Durbin will understand that. So I kind of doubt they would escalate. But you know what? We live in crazy times. You never know.
Well, I just think that it's possible you could draw a good judge, and it's possible you could draw a good panel. It's possible the Browns win the Super Bowl this year. I'm hopeful. But it's also highly expensive, and no one reimburses Leonard Leo for this, correct?
That is correct.
So the chilling effect of this is immediate. And I know you want to hold off until after you have an actual, you can't be tossed out for lack of ripeness. But I don't know that you've gotten much attention for this. But if they begin calling witnesses of public people, the rest of the country ought to be worried. I mean, they will not stop if they get Leonard. Is that your opinion, or am I just shooting in the dark here?
No, I agree with you. Look, one thing that depresses me, where is their COU? Where are what I call traditional liberal organizations that defended the right of Nazis to march for Skokie? What happened to these people? It is utterly depressing how the progressives are suppressing constitutionally protected rights and reversing themselves after decades of at least being even handed in the space. and look at and at one point you made that I think is excellent. That is also about reporters. There's a lot of people who think there's something sacred about being a reporter. I can assure you, as a matter of law, there is nothing more sacred about First Amendment rights of a reporter than First Amendment rights of an average American.
That is absolutely correct. At the state level, there are some shield laws, but at the Senate level, there's nothing to stop them from subpoenaing any member of the United States that they don't like. And that's what the rule ought to be clear. David Rivkin, I want to thank you. Just to make sure that I don't get hit with this, I hired Baker and Hostetler as my co-counsel back when now Judge Leon and Richard Hauser were partners there. So I've got a conflict if we're going to go back 20 years on the Desert Tortoise litigation. But that was one time, only one time. David Rivkin, thank you so much for joining me. I appreciate the letter. Keep up the good fight.
Good to be with you.
Thank you.
Thank you.